As we pass through the 150th anniversary of the Civil War, you've probably heard a lot of commentators say, we're still fighting the Civil War. You probably heard it too often. Time magazine covers. And if you're following the New York Times, they're publishing a daily article about what happened on this day 150 years ago to keep Americans familiar with the course of events. When discussing constitutional issues, we have a tendency to re-argue the Civil War, even though it doesn't always get mentioned or it isn't always explicit. There's an interesting moment in the last Supreme Court term when the case about California's Proposition 8, the gay rights issue, and California's decision on 2008 Election Day to limit marriage to one man and one woman. It's an interesting moment when Antonin Scalia and Theodore B. Olson were talking to each other. This is a clash of allies, really. Scalia wanted to know what the law is. Now, this is an old phrase from John Marshall's Marbury versus Madison opinion. Supreme Court is not supposed to make the law. It is supposed to declare what the law is. And he said, I'm curious, when did it become unconstitutional to exclude homosexual couples from marriage? 1791? 1868? Olson was ready, and he replied, Justice Scalia, when did it become unconstitutional to prohibit interracial marriages? Now, Scalia could have ducked the question, and eventually he did say that Mr. Olson should not be asking him questions. Produced the laughter in the audience. But Justice Scalia rose to the bait, and he said, at the time the Equal Protection Clause was adopted, that's absolutely true. Justice Scalia, sometimes in error, but never in doubt. It was an extraordinary answer. And it displayed Justice Scalia's extraordinary confidence, which his critics call something else, and a confidence that no one's going to connect the dots. Because interracial marriage did not become constitutionally protected and a right until 1967, when Loving versus Virginia is decided. And at that time, 17 of the states, including, of course, all the Confederate states, retained laws against interracial marriage. So Justice Scalia's announcement that it's absolutely true that it became unconstitutional in 1868 sits uncomfortably with the fact that no one in a certain portion of the country knew it for almost exactly a century. What's going on? Well, we're really talking obliquely about Justice Scalia's favorite theory, and that is originalism. You try to figure out what the original meaning of the Constitution is, and judges enforce the original meaning and nothing but the original meaning. And Justice Scalia has a problem with his answer. There is just a ton of evidence that no one in 1868 anticipated that the Equal Protection Clause in the 14th Amendment would ban state laws against interracial marriage. Abraham Lincoln felt the full force of this issue when Stephen Douglas engaged in overt, egregious, and controversial, even in that day, race baiting. Douglas said, abolish slavery, men who are black will lie with women who are white, and this is a horror not to be contemplated. Lincoln felt it in the arguments over the 13th Amendment and the Emancipation Proclamation, when people in the House and people in newspapers spoke of the miscegenation ball sponsored by King Abraham Africanus I. These were very explicit racial points. Now, there's no logic to this, but there's a great deal of emotion. And they understood something, and they're taking advantage of it. We ought to make it clear in our minds that if Abraham Lincoln was right and there was or ought to be a link between the Declaration of Independence and the Constitution, if the phrase all men are created equal really means everybody has the same unalienable rights, and those unalienable rights include the right called the pursuit of happiness, it probably has something to do with something we all find basic and fundamental, and that's to share a life with the person you love. And that includes sharing the life, the person you love regardless of race, and we shall, of course, later consider whether it includes regardless of other irrelevant factors. But the truth is, that was not part of the new birth of freedom in 1966. A Virginia statute made it a felony for any white person to intermarry with a colored person. The Lovings were convicted of violating the statute. They are forced to live away from their family in the District of Columbia. And so they allowed a challenge against the Virginia statute. And despite pressure, public attention, celebrity, all things they did not want. Now, this statute was explained in one basic idea. The Virginia legislature said the sole purpose of this law is to preserve racial integrity, to prevent corruption of blood, the creation of a mongrel breed of citizens, and obliteration of racial pride. This is also rhetoric that you'll find in the documents associated with the Declarations of Confederate Independence. Question is, could such a statute exist in America in the latter half of the 20th century? It took a long time. Remember, this is 1967. It's almost a decade and a half after Brown versus Board of Education. It's after the issues of segregation. It's after the Civil Rights Act of 1964. It is basically an issue following up all of America's new understanding of racial equality, born of Dr. King's speech, the Civil Rights Act, the efforts of Presidents Kennedy and Johnson. Case gets to the Supreme Court in a time of enormous racial stress. Chief Justice Warren writes the opinion. It is not a unanimous opinion, unlike Brown versus Board of Education, tragically so. And Earl Warren makes several basic points. I talk about loving because, in my view, this is a moment, even more than Brown versus Board of Education, where we come to a time when one can really say the constitutional law has been redeemed. The betrayals of the Supreme Court against the 14th Amendment are, if not exactly corrected, they're at something of an end. One, Earl Warren says, something Antonin Scalia finds objectionable, evidence of original understanding is inconclusive. Now, I like Earl Warren. And so what I'm about to say is not meant to be criticism. But I think Earl Warren is not exactly telling the truth, because the evidence of original understanding is all too conclusive, all too clear. The real question is whether the court is going to live with that heritage of racism or move to a broader principle, cleansed and redeemed and free of the kind of racism stated by the Virginia legislature. And second, Earl Warren says, more clearly than he said it in Brown, or in any case between Brown and Loving, racial classifications are presumptively unconstitutional, and a state which uses them has some very special explanations that are necessary. They must show necessity. They must show emergency. They must show conclusively that those racial classifications are so indispensable that order, human life, compelling interests of the states will be lost without them. A very high standard. Chief Justice Warren also says Virginia's not going to come close to that because what they've said in favor of the statute is illegitimate. Not only is it not compelling, not only is it just an interest that's less weighty than the interest in equality, he says rather authoritatively, preservation of white supremacy and the integrity of the white race is no business of the states. It is not a legitimate object. It is eradicated from American law for all time. And finally, he says one thing more. Now, it's kind of an after-the-fact rationale at the time. But he says, marriage is part of the liberty secured by the Due Process Clause. This is not only an equal protection case, but it's a liberty case. The freedom to marry has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men. And there's the link. I think it's the first time the orderly pursuit of happiness, that reference in the Declaration of Independence, is there. Lincoln promised it. He claimed it was there when there really was no legal basis for saying it was there in 1858 or 1854, but there it is. That link is not forged in Brown. It's not forged in many of the cases discussing the Equal Protection Clause or the Due Process Clause. Marriage is one of the basic civil rights of man, fundamental to our existence and our survival. And following that case, Loving, there are a number of other cases dealing with marriage. Justice Scalia and Justice Alito and some others can say that these issues are not addressed by the Equal Protection Clause of the 14th Amendment. But they cannot say that in a way that's consistent with Justice Scalia's answer that the principles necessary to render this case are there in the constitutional text in 1868. As far as I know, originalists have never explained to me how Loving versus Virginia is decided, unless they are willing to concede that link between the Declaration and the Constitution was forged with the ratification of the 14th Amendment. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.